Good afternoon, everyone, and thank you for tuning in to our webinar today on Biotech Startup 101 IP Management, presented by SGInnovate and SINERGY. My name is Brian, and for those of you who don't know about us, we are a government-backed investor in Singapore with the mission to build deep tech innovations. At SGInnovate, our work involves connecting with the global deep tech ecosystem, working with entrepreneurial scientists to bring their innovative research from lab to market, as well as developing deep tech talent. Today, we have an amazing panel of speakers who will be sharing some common mistakes biotech startups make regarding IP management, and they will also be giving some tips on how to better manage your intellectual property. I would also like to encourage our audience here today to share their thoughts on this topic and engage with our speakers by using the Q&A box below. And with no further ado, I will now pass the time to our moderator for today, Suresh. Suresh, please.
Thanks very much, Brian. Good afternoon, everyone. Thanks for joining us. And I'd like to thank SGInnovate for inviting me and the rest of my panel. I think we are very happy to be here. Very quick introductions. I've got three speakers with us today, panelists. Akbar Vahidi, he's a co-founder of Allozymes. We have Sara, Holland, who's a patent attorney with Clarkson. And we've got Ken Noonan, who's an investor with Lightstone Ventures. So I thought I'd just set some very quick context to today's talk. And we talked about biotech startups and some of the important issues that we think about in IP management. And just before this, I was talking to the panelists, and I thought I wanted to frame an idea with the rest of you to think about intellectual asset management as opposed to intellectual property management. From my vantage point, having worked with many startups in my time, I realized that, that many of us actually think about IP in a very narrow, defined way. In Singapore, at least, we've done a very good job about IP awareness. And most times we think about IP in terms of patents, and it's very important for a biotech startup in particular, right? That patents are usually a big part of your intellectual asset base that you have. But oftentimes I find that companies don't actually think broadly enough that in their vault, right, that they have more needs for intellectual assets in terms of know-how, for example, right? Customer lists, your contacts, your confidential information, and very, very importantly, what's in the minds of the people you will work with, your consultants, your employees in particular, right? The biggest asset for us in A-Star, I always say, is walks on two legs, right? It's our people, and oftentimes we don't manage that information flow and the confidential information in the heads of people well enough. And I found in the case of many startups, that's one of the last things to think about, right? We think about protecting our patents and our copyrights, software even, right? But we don't really think about the knowledge that's being held in the heads of our staff and our employees. And that's a big area which I thought that, maybe in the course of this discussion, the panelists and I can weigh in on that about some of the pitfalls if we don't think this through very carefully. The other point is that really in any company that, again, from the experience that I had, your IP or IA strategy must align very closely with your business strategy. That comes first, right? Your business strategy comes first. And then you think about, what is the intellectual assets that you have to back behind your business strategy to make your company succeed, right? So in defining an intellectual or asset or IP strategy, you have to be very clear about what is your business strategy, what is the outcome that you want to get. Is it a product charter? Is it a service charter? And then what do you need in order to back that up, right? And how do you go about getting it? And oftentimes we find that founders or usually the research people within the startup are very fixated about creating IP and owning IP within themselves. And the strategy does not include multifaceted points like collaborations, open innovation, in-licensing, acquisitions, right? And things and so forth, right? Which would then formulate your intellectual asset strategy as you go along. So I thought I'll just put those two thoughts out there, IP, intellectual asset strategy, aligning very closely with the business strategy, and thinking beyond IP to intellectual assets, because that then weighs into your strategy on how you want to collect, create, acquire, protect, and then of course, commercialize and monetize those assets which you have, right? So I'll pause there, and I thought I'll then invite in order Akbar, Sara, and then Ken to share their thoughts on this area, and then of course I think we will open up for a discussion, and if you have questions or comments, that would be fantastic, and then the panel will take it from there. So can I hand it over to Akbar, please?
Thank you, Suresh, and thanks for SGInnovate for setting up this, as well as SINERGY, and inviting me to talk. It's a pleasure. I'm Akbar, CTO and co-founder of Allozymes. And to those of you who may not know the Allozymes, we are a young startup, a deep tech biotech startup. We are working in industrial biotech for enzyme engineering and basically preparing microbial strains and new enzymes for manufacturing a lot of different things. And for today's discussion, I believe, as Suresh laid out some of the major points, I just like to talk a little bit of things from founder's perspective and my own experience. And I would start with IPs, and as we all know, some major form is patent. I think one of the things that many startups know about IP in the early stage is very little. Of course, we know we should have some forms of IP and own that. This is very general idea. But to me and my experience, many startups, just early stage startups, just think of or know about filing an IP. And they know very little of the rest of the journey, or managing it, or maintaining it, or how to monetize that, or how to use it for commercial purposes. And that's, I think, one of the issues. And even normally for their filing, often early stage startups will choose the easiest, or can say cheapest way sometimes. So may not lead to the quality IPs for them, because IP would be their asset over the time. And I think also not only, as I said, not only the filing in the early stage should be managing it, should be planning how to form a patent portfolio for the company, even at high level. Yeah, maybe in very early stage, we don't know all the details, but at least we know the nature of business we are going to do and what are the important verticals that we will touch. At least we should have plans for it, an idea how to build IP around it. So that is my own experience over the time of founding and building Allozymes. We learn these things and constantly plan and continuously think again about these things. So it's okay to change plans from here and there, but not planning is, I think, not a good idea for startups. And often startups, because we know, have limited resources in terms of capital or people, so they feel like when they grow bigger, they will do a lot of things. But I think it may not happen, or it may be quite difficult to execute when you become bigger if you don't have much clear idea in the early stages of the company. So I would encourage early stage companies to really think and learn about IP management, portfolios, and building it from the day one. And I think, as Suresh nicely mentioned, I would also like to mention about IAs, or intellectual assets, which I think, at least from my own experience, at least in the early stage startups, is the people and the team. And then when the team operates and grows and we execute projects, then we add know-hows and many other forms of them. But yeah, the key point is the people, at least in our company, we are very cautious about, like, we are very selective on choosing right people and, more importantly, maintaining them. I think you may be able to land some good talents, but retaining them probably is more challenging. So I think it goes back to company culture and how you handle and balance between working and building this know-how for the company, as well as rewarding the employees in this way. But I think there are a few things I would like to highlight here. So basically, for the company, like early stage startups, as I said, normally we have some form of IPs, but so nicely mentioned, their people are more stronger assets in the early stages. And for us, we really encourage inter-collaboration, discussions, innovations within the company. So even our office and basically lab is structured in a way that we sometimes actually force people to collaborate and talk to each other and be innovative rather than just do some piece of work and leave. So we feel like by doing internal discussions, you will learn from each other, and sometimes even a person from relatively from other field may have some ideas for your field, which you will be surprised. And I think this is one thing that sometimes we often forget. So it's a culture to build in the company for constant collaboration and discussions. So we even have discussion room and all this. So people should go there and handle some projects or discuss their daily issues together. And for the innovation part, I think is really is the main asset of any deep tech company in the early stages and even maybe later stages. So that's why we have to be innovative, but in order to do that, we have to have some means or build some structure to capture it, meaning that like know-hows are created, data and some information are built, but if a company doesn't build a structure, for example, as simple as recording them, it will lose a lot. So I can say in traditional or like at least non-commercial setups, it's common that one person does one project and leaves, and all its samples, data, designs just goes off with that person. So some early stage companies also may have this kind of structure because they come from this kind of non-commercial setups, or at least they may feel like they don't have enough means to build a structure and they will just wait to grow bigger to do that. But I would think that is not a good way of doing it. So we should start from the beginning to build a structure of recording, maintaining, and using this kind of know-hows and other piece of information. So example, in biotech and industrial biotech, we do a lot of design, we test them, we learn from that designs, and this cycle goes on. And there are traditional ways of doing it just manually. There are traditional ways of doing it more automated. But for both methods, if you don't have proper recording systems, you will lose a lot of information and a lot of efficiency and time will be lost. So company will be not benefiting from these things. But if we put a structure, like for the data, basically acquisition and also reporting and also structuring the data in a way that you can keep searching them or structuring them to learn more, and some IPs or know-hows or protocols comes out of it, it will be more beneficial for company over the time. So these things doesn't come by quick decisions, but it just needs some structure to build and then wait for the results to slowly come to the company. But I also want to mention something here. Although we know about like IPs and patents, and the other side we have trade secrets and confidential information or market information, For startups, these are really valuable because sometimes we spend so much time as founders to learn something about market and certain products, and these are really valuable. But for startups, I believe, again, we should have a good idea about how to protect these things, because normally IP is more in a way protected by structure of patent laws, but trade secrets and some other information may not be as easy as a patent to protect, but needs kind of several layers of protection in the company. That's why one of the reasons, like startups, early stages kind of emphasize more on the patent. That's my own thinking. But I think there are some ways of doing it right in order to build some trade secrets and maintain them in the company. One of the things is because we know that normally these trade secrets and confidential information, if maintained within the company employees and business partners, more or less, it will be maintained. So most of the cases that I'm aware, it comes from these two sources. And I think articulating and putting right agreement would be the best for startups. So we cannot just rely on NDAs or CDAs only when we are talking about confidential information. So example, for employees, companies should prepare really good confidentiality and compliance agreements. It can be really difficult and it needs very good lawyers to prepare for the company, but it will put the company in a good position to maintain its information. And in also partnerships, we should follow the same. So we shouldn't think like early stage startups don't need to do some paperwork in order to kind of protect themselves. I think this is one of the basics that we should follow. Sometimes, like I feel often we may get excited and release information that then is difficult to really protect after that. Yeah, I think that's about my ideas and points. I would be happy to discuss further while others are adding points.
Thanks very much, Akbar. Good points. I think the idea about employees, I think it's a point that most of us don't pay really close attention to. So I think it's good that you underscore that. Sara, can I hand over to you to put on some of your remarks, and then we can take it forward. Sara?
Yeah. So I'm Sara. I'm a patent attorney based in Nottingham in England. And before that, I was a postdoc for about 8 years at the University of Nottingham working on molecular biology and yeast. So I've got this fairly extensive academic background, and I'm now a UK and European patent attorney. So I do have quite a strong interest in IP coming out of universities and educating academics, I guess, because I remember as a postdoc, I knew nothing about IP. I didn't know anything. I probably cared even less about it until I left. And there's a lot of things I wish I'd have known back then. So I think a lot of what I was going to say, Akbar and Suresh have already kind of touched on and spoken about. So I think we find that founders, they've got an awareness that they need some IP, and perhaps that means clinging onto a patent. They've got to do a patent application. We understand that founders have not got that much money, but the whole point of one of the points of getting the IP in place is so you can look attractive to investors and get, people on board to give you the cash. But I think sometimes, and perhaps Ken can talk about this later, we find that rather than having what could perhaps be quite a rubbish patent application because you've not paid very much for it, so you get quite a poor application, having a well thought out IP strategy that shows what you're going to do, that you're serious about your IP, that can be perhaps more attractive, especially at the seed and Series A perhaps level, to show that you're serious about your IP. So, as we've already talked about, IP strategy is not just what patents are you going to file. You need to look at start off with your business plan, like we've already said, and how is your IP and other assets going to support that? So, are you better off protecting your invention with a patent or keeping it as a trade secret? If you're going down the patent route, how are you going to ensure you've got longevity of patent protection? So what are your pipeline products? Are you going to try and protect your product now and then improvements later on, or try and then protect the methods? If you are looking at trade secrets, you need to understand what things need to be in place for it to qualify as a trade secret. So in the UK, at least, trade secret needs to be secret, obviously. It needs to have value because it is secret, and you have to have taken reasonable steps to keep it secret. You can't just, oh, it's secret, but we've not really put anything in place. So, do you know what I mean? So you have to have you need to be able to show all this if it did go to court, that it should have been classed as a trade secret. I think Akbar mentioned data. Have you got data? There's a lot of value in data that I think a lot of companies don't realise, because they're collecting data as a side product, perhaps, of the service they're offering. Is there anything in that data that you can license out? And also, especially, is your company business facing, or is it client consumer facing? So probably if it's consumer facing, your branding is going to be very important. And I think we're seeing this quite a lot with all the cultured meats. There are quite a few strong brands out there that are already kind of, to me anyway, household names that we know about because they're out there and marketing themselves. So sometimes, and it's something that we do with some of our clients, is we'll sit down for like half a day with a founder or a startup and go through their IP strategy and give them a written IP plan that aligns with their business model that they can then use in their pitch and show to investors. So yeah, I think one of the problems is founders perhaps not appreciating how important the IP is in the first place, because it does cost money and you don't really see much for it. And it's kind of, you're wearing all the hats to start off with, your marketing, your HR, your everything. And then you've got IP to deal with as well, which perhaps is a bit of a distraction, but it is important. It's also important to realise, and this sounds like a sales pitch, but it's not all patent applications are equal. So you can pay a small amount for something that's not very good, really, because the problem with a patent application is once it's written, you can't add anything to it. So when we draft applications, we try and build in a lot of flexibility. So this is what your product is, but maybe in a couple of years' time, it's going to have this feature, it's going to have this feature. So we need to build all those options in. There's one that I'm working on at the minute. It's not one we have drafted or the US attorney we're working on with, it's somebody else. But this application is very short and it doesn't allow for the different combinations. So nowhere in this application does it actually cover the client's product. There's the clients now, so say the patent application is drafted to a combination of A and B, and their client has now found they don't need B, so it's just got A in it. But we can't claim just A on its own because this patent application was not drafted very well. So that's, I think sometimes your first patent applications can be perhaps some of the most important, and it's important to make sure it's got all this flexibility in it. I think a lot of synthetic biology is still in academic labs and coming out of academic labs. So you've got perhaps a conflict of academics wanting to publish, and they think the patent system perhaps prevents that, or they can't publish it because they want to patent it. And that's kind of true, but only to the extent that as soon as you file the patent application, you can then publish it. So there's nothing to stop you publishing your research in Nature as long as you file the patent application first. So that's one thing I think sometimes academics don't understand. Another thing that you would need to think about in your strategy is how you're going to deal with your freedom to operate. So a patent application, if you get it granted, will give you the right to stop other people doing your invention. But it doesn't mean that you have an automatic right to do the invention yourself, because somebody else might have got a patent application that stops you doing your work. So say I've got a granted patent to the use of yeast promoters to express protein B, and then you find out, oh, particularly mutants of a certain protein, a certain promoter make the promoter better. I can stop you using your special mutated promoter because it falls within the scope of my patent, but independently your mutated promoter could be patentable itself because it's new and inventive. So freedom to operate and patentability are quite different, and you need to show at least, so with freedom to operate, you can't prove a negative. So you could throw endless amounts of money at a freedom to operate exercise, and you can never be 100% sure you're not infringing anything. So especially early on when you're starting off, you've not got much money, you could do a very targeted FTO search to try and make sure there's nothing obvious out there that's going to stop you commercializing your technology. Or at the very least, you need to kind of build that into your business plan and your IP strategy to show, you know FTO, freedom to operate, is a thing. How are you going to deal with it? Are there people that you think you might need to get a license from? Are they likely to give you a license? Are they going to be kind of a major competitor? So they're probably not likely to give you a license. So that's freedom to operate. I think, as Akbar said, I think it's useful if the founders and the scientists doing the research can learn a little bit about IP, particularly in terms of data that you need to support your application. So in biotech, you tend to need at least a bit of data because it has to be plausible from what you have shown that your invention is going to work. But depending on the breadth of data you've got, you may end up with quite a narrow claim scope. So say we're talking about a drug to treat cancer. If you've tested your drug only on one breast cancer cell line, you might get a patent granted, but it might only be for breast cancer. Whereas if at the same time as doing that experiment, you threw in some, I don't know, colon cancer cell lines, lung cancer, so you've got all that in your application, then you're more likely to get the use of that drug to treat any cancer because you've shown it works. Because especially for cancers all behave quite differently. So often the patent examiner, when your patent application's examined, will say, well, you've only shown it for breast cancer. We don't know if it's going to work for these others. Whereas if you've shown that, and if the scientists know that that will be useful, they could do it at the same time as doing the experiment, because I think it's quite a lot easier to do it at the same time rather than revisit and repeat an experiment just for the purposes of patent application. So yeah, I guess make sure your research staff know what your business plan is, what you're aiming for, so they can invention spot, because quite often inventions come off as side shoots to your main project, and that could be something that you want to look at. I think also Akbar said about having inventor capture procedures in place. How are you going to do that? How do you document who invented it? Were there any outside collaborators? Because if you've got inventors from different companies or different institutions, that impacts on ownership. So ultimately, who owns it? Is it you? Is it somebody else? Is it co-owned? If you are using something under a material transfer agreement, does that allow you to use it for commercial purposes? Same as if some of your research was done under academic licenses, like kits you bought for an academic license, but then that academic research begins to move to a commercial side, do you need to relook at what licenses you need there? So I think all of these things are things that could come up in due diligence when investors are looking to give you money. So I think you need to have thought about them and have got plans in place. And then also, it's not an IP angle, but there's regulatory aspects that you need to think about as well. So different jurisdictions. So in the US, CRISPR edited stuff is counted as non-GMO. In Europe, CRISPR edited things is classed as GMO, and you can't, they won't let you use, I don't know, CRISPR edited wheat because which doesn't make sense, because in Europe you can have chemically mutated things, which obviously could do all sorts of different mutations. So you need to think ahead, especially if you've got a choice early on, which route are you going to go down? Some routes can make things easier and some can't. I think that's all I had to say so far.
Excellent, Sarah. Thanks very much. I would echo and on the pain of sounding self-serving. Please do invest if you have to invest in a good IP lawyer and a good attorney. It's a relationship that's worth keeping. Having acted for investors, oftentimes we look, or at least the investors I've represented, look for where you placed your investments in terms of your IP. Where are you spending, and where's the prudence in that. But that's not really for me to say. I think Ken knows a lot more about that, because he's going to represent the investor side of it and talk to us a little bit about what are the investors looking for. So I invite Ken now to weigh in and give us some comments. Ken, please.
Yeah, thanks, Suresh. Let me give you a little context to Lightstone. So we're a global venture capital fund. We have 3 active funds right now. 2 of them are focused on the US and Western Europe. The other is focused on Singapore. I'm the managing partner of the Singapore fund. We only do life sciences, and frankly, we only do drugs and therapeutic devices. In Singapore, we've been here about 6 years now. In Singapore, we've learned that we have to do what is called venture creation. Venture creation means we walk the halls of NUS, NTU, A-Star, Siri, Duke NUS, etc., looking for technologies and potential founders who we think, where we think the technology could, under the right circumstances, have a commercial value, and the founders are willing to participate with Lightstone in the creation of a new company. I need to support both Sara and Suresh. All patents are not equal. All patent attorneys are not equal. Biotechnology is a specialist area, to put it mildly. It's a very crowded space. The good patent attorneys are extremely expensive, but in the end, very worth the money, in my opinion. So we work almost exclusively, at least in Singapore, with Morgan Lewis. There are a variety of other patent firms out there that also are specialists in biotech that one can work with. You won't find a lot of those specialists in Singapore, so you're almost certainly going to have to reach out to either the UK or the US for that type of support. We actually work with Morgan Lewis in San Francisco. So in our venture creation process, as I say, my team walks the halls, finds technologies and founders that they think might be worth supporting. We then do frankly, a very significant amount of technical, commercial, and IA due diligence. We involve Morgan Lewis from the very beginning. And so Morgan Lewis will both help us do the freedom to operate analysis, will help us to do the what type of IA actually exists within this company. And they will help us before we make the investment in creating, to Sara's point, a plan for what we're going to do going forward. Lightstone has been around for a long time. We have never invested in a company that doesn't have an IA plan. And frankly, we probably have never invested in a company where we don't think there is a patentable material. Doesn't necessarily have to be in a patent at the point we invest, but we need to be convinced there is patentable material that we can protect. We invest in our seeds about $6 million, and we usually invest for up to 18 months. We're very hands-on, and the IP attorneys are themselves very hands-on. Once we make the investment, the IP attorneys remain involved. We typically have a review with all of our portfolio companies about every 2 months. Those reviews are attended by the attorneys who help us think through whether there is some new material that is patentable, and whether we're better off, as Sara pointed out before, in looking at know-how and at trade secrets and not patenting. And in a recent investment we've made, much of the early value is in know-how. We've concluded that either publishing or frankly patenting the know-how will give our competitors far too much advantage. And so in that particular case, the majority of our value currently sits in the know-how. The know-how, frankly, is processes and procedures that we expect will lead to drugs somewhere down the line, and it is the drugs that we will actually patent. I think you need a fairly sophisticated, biotech-educated patent counsel to help a startup company work its way through those challenges. As was pointed out by both Akbar and Sara, many of our founders, this is their first company. They have very little idea about IP. They have very little idea about patent strategies. they have very little idea, to Sarah's point, about the difference between the EU and the US with regard to things like CRISPR. Again, unless you have a sophisticated patent attorney working with you, you're going to miss some of that, and I think it inevitably lose value over time. So I think what I've done is, frankly, support what Akbar and Suresh and Sara says. You need a good patent attorney. You need a biotech specialist. You need to protect the different types of value-creating IA, and you need to be thoughtful about your patent strategy. Part of the reason, to end my diatribe here, part of the reason you need to be thoughtful is good patent attorneys are very expensive. And as a consequence, you have to, no offense to Sara, you need to manage your patent attorneys, and you can only do that as you learn what it is you have and where the true value points lie. So I'm continuously, probably lecturing is the right word, my team, that we need to be sure that our portfolio companies are using the IP budget effectively. And that's why we always partner with the same patent attorney or same patent group, because they know what we're willing, able, and capable of spending. So to Suresh's point, I think creating a strong relationship with an educated IP group is particularly important in the biotech or device space. So Suresh, I'll stop there and let people ask questions.
Thanks, Ken. I mean, good advice for our aspiring biotechs as well as startups. I think it's the chain runs through, the string runs through quite neatly across. We've got two questions. I thought I'll just throw them out. The first one was, are there instances where it's better not to protect IP? The suggestion here was for humanitarian reasons. You know, there are two parts to this question actually. I think it's why do we take that one first? Are there instances where it's better not to protect your IP? I think Ken mentioned that you know, in your discourse a little bit, that, you know, sometimes it's better not to file because the quid pro quo for patents is that you have to publish.
Yeah.
Right. That's the quid pro quo, and when you publish it, your competitors know what it is, and sometimes it's better not to go for that protection. Maybe I'll ask Ken first, and then Sara to just comment on that, and then Akbar very quickly, if you've come across that in your field, times when you better not to file, right? And then maybe you could talk about the humanitarian part as well, which I'm not quite sure it will apply to for a startup, but I've seen that happen in other instances. So Ken, maybe to you first, and then Sara and Akbar.
Yeah, in our most recent investment, it was clear to us that the processes and procedures that the founders had created was a very, very, very important element of the overall IA. But as soon as we published it, whether it's in a publication or in a patent application, it's impossible to control the use of the processes and procedures. There's no way to even know. And so we've concluded that we're going to keep that as trade secret and will not, frankly, file patents on that. So I think there are very often situations where you don't want to file. You want to file around the ultimate product, especially in biotech, where the ultimate product hopefully is a drug.
Yeah, I think I agree with all of that, and just talking about the humanitarian reasons. I don't know. I feel sometimes like patent attorneys and the IP and big pharma are all kind of seen as money grabbing. We just want to make money, and I do, especially when COVID struck. I had these kind of existential crises, thinking, what's the patent system? Is it right? Is it wrong? But ultimately, say you want to get a drug to market. So humanitarian reason there, you want to save people's lives. Somebody somewhere is going to have to invest a hell of a lot of money and time developing that drug. They're not doing it, well, they are partly doing it for the good of the world, but they're also doing it to make money. They've got to make money. Scientists need paying. No, all these people can't work for free. So especially in pharma, one of the main reasons to get your IP is so you can recoup your investment and make a profit, which you can then reinvest in other drugs. So with the COVID thing, a lot of the companies, they've got this money, so they can go off and make drugs at cost and make vaccines at cost because they've kind of built that up before. And with a lot of the drug repurposing things for COVID and for other diseases, those drugs were only there in the first place because of the IP. So the only reason we've been able to act so quickly in certain things like the mRNA vaccines is because people were already working on it and already had IP protection to it. So I get that sometimes perhaps think, oh, everything should be free and published. And some of my friends in academia think that they're publishing all their genome-wide association studies and things for other people to work on. But without that security of being able to protect what you invent from it and make your money back, chances are, but nobody's going to take it on. It's just going to be a dead end. But that's something I didn't really appreciate until I left academia. I thought, yeah, publish it, and then somebody somewhere is going to cure cancer because of my little bit of research. But it's not going to happen. So.
And beyond that, as I think we know, Sarah, there's a hell of a lot of know-how that Moderna or BioNTech have that's not in a patent. And to just say, here's an open patent, go make RNA vaccines.
Yeah.
They're going to fail miserably.
Yeah.
And so I agree with let's find a way to have BioNTech, Moderna, et cetera, work with potential manufacturers, but left to their own devices, that the uneducated manufacturer just is never going to produce efficacious vaccines.
Akbar, comment on that question?
Yeah, I think as they mentioned, of course, as I said, we are a young company. We are also learning. But what we are learning is, as Ken mentioned nicely, sometimes certain protocols, procedures, or systems that you build is better to keep in your company. I can say, example, if you have systems that automate and you integrate a lot of things to work together, you don't need necessarily to publish and patent these things because these are hard to replicate, and also it gives good advantage to the company. But if you are really going to sell a product, as like Ken mentioned, a drug or enzyme or microbe, sometimes it's difficult to not patent it and just try to commercialize it. So it depends on the nature of the thing. Yeah, mostly we decide, and we also get a lot of consult from our patent attorney that we are working with.
Yeah, if I can add to that, is that, a well-drafted patent document will disclose what is legally required for you to get the IP through, and then you keep the secret sauce to yourself. I mean, that's what when we draft our patents, that's how we spend a lot of time with our attorneys to make sure that we meet the requirements, the legal requirements, but you don't do a full Monty, right? So I mean, that's the secret to do that. And that's why, again, underscore the point that getting a good patent lawyer and a good attorney who understands your business and understands the way you operate, I think it's really critical, right? So good advice from our panel. Matthew had an interesting question. Would it be possible for a biotech startup to be successful without IP, strong IP, and would having strong IP in place equal commercial success? Akbar, you try take that first, and then I'll invite the other two. I thought it's an interesting question.
I think in my experience, it's very tough in biotech. As Ken mentioned, most of investors expect some form of IP from the early stage companies to invest. And I believe when you don't have clear IP or the materials for it, it's difficult to really put a value in the company in the early stages. And as I said, in the later stages, when you want to commercialize, there are other difficulties. So that's why I think that if you are going for VC type of money or institutional money, it's really hard to go without IP. But if you are just backed by some other capital in the early stages, maybe you can start with. But over the time, you still need to build your IP portfolio. But I'm just saying, even in that start, it's really hard without IP or the proper strategy for it. I see it very difficult.
Yeah, Suresh, the only point where I can see where you might not need IP is if you're a service company.
Yeah.
But on a product company, frankly, there's no chance in the world that Lightstone would invest in a company where, as I said before, we don't think there's protectable IA at least, if not IP.
Yeah, I agree. I mean, in the deals that we've done with biotechs in particular, not just IP and strong IP, but exclusivity. Very, very seldom have I done a deal with a biotech that doesn't require exclusivity. My own, or as an investor, would I recommend to my investor clients, that they should invest in a company that doesn't have exclusive rights? If it's a product company, I think you're right, Ken. Absolutely. I dare say even in services, sometimes we would look at it very carefully, but that's probably an exception. The second part of the question was an interesting one. Would strong IP guarantee success? I'll ask Ken to comment on that. My immediate answer would be absolutely no. But maybe Ken, you can comment on that, and then maybe Akbar as well.
No, it's absolutely no, Suresh. It comes down. The IP is important, but it comes down to the management team, the plan, the investors, and a whole bunch of other things. So having great IP, I can tell you with certainty, because we've had a number like this, does not guarantee success.
Yeah, at least one of those is simply because, especially with therapeutics, you have to get the IP in place so early on. We've got clients that we've got strong IP to antibody therapeutics, but then in clinical trials, it doesn't pan out. So it's a shame. They've spent a lot of money and they've got like some really good patents, but the commercial product doesn't work. So unfortunately.
Yeah, it's sad. I mean, in the graveyard of companies that I've seen, some of them with fabulous IP, but with a terrible management team, no business plan, no idea what they were doing, and it was a crying shame because the IP was really interesting, but they just had it wrong. They just got the whole business plan wrong and failure to execute. Right. So I think, and then married together with terrible investors that just didn't know how to help the company. So I think it's a cocktail of things, right? It's not a strong IP in itself. I think it's essential, but without a strong management team and a strong business plan that one that's executable, you're not going to go very far with that.
Yes, let me support you on that. The investor syndicate is incredibly important. If you've got 2 or 3 weak investors who don't understand what they're letting themselves in for, you have a problem. So we probably have a network of 25 venture investors spread across the world that we will invest with. We know hundreds that we just don't think have the wherewithal or the deep enough pockets or the experience to dabble in biotech.
Absolutely. Daniel had a question. Daniel, you may want to chip in on this because you asked, are there ways to improve the biotech IP process based on your experience, or is it the way it is due to regulation or past mistake? Not entirely clear what you're asking, Daniel. I think it's an interesting point there. I think about the regulation and the process. Sara, do you want to take a crack at that, or maybe Daniel can clarify what he's asking?
I think partly it's just making sure that people are aware of, for me, the requirements for patentability, because I don't know, especially with like academics, they want to publish their research, and quite often they don't realise that once they've published it, you can't try and get a patent application for it. Well, some countries have grace periods, but it makes it very difficult. So I think making sure your staff, your research team know that, if you talk about your research at a conference, in a poster presentation, online, in a chat room, that is all classed as prior art, which can be cited against you and can stop you from getting a patent application. So yeah, there's been mistakes with that with one of the universities. The inventors didn't realise that their own journal articles counted as prior art, so they didn't tell us about these until like 2 years later when it popped up in a search report. So part of that, I think, is making sure the university tech transfer officers understand that and make sure that the academics they work with So I think there's a bit of education needs going on. But if you've got any other, if you meant anything else by that, then yeah, let us know.
Daniel's got another question, and his question was, is the process easier depending on country? And then any particular difference between Singapore and the UK, Sarah?
So assuming you're talking about patents, the overall patentability requirements are very similar. So it needs to be new, it needs to be inventive, it needs to be sufficiently disclosed. That comes back to what we were talking about earlier, making sure you've got enough information in there so that the skilled person can put your invention into practice. But each country has its own like interpretation of that, really. So in the US, for example, for an obviousness type objection, they can or do tend to combine lots and lots of different documents. So they'll put like 5 or 6 documents together, prior art documents, and say, if somebody read all these, then they would come to your invention. Whereas in Europe, it's normally 1 or at most 2 documents that the examiners can put together. So arguing for inventive step is different in those 2 countries. Some countries like South Africa, it's just a registration process, so it doesn't get examined really at all. So it just gets granted. And then if you wanted to enforce that patent, that's when you would find out if it's actually valid. So for countries like South Africa, what we tend to do is wait until a patent's been granted in Europe or the US. So we know those ones have been examined and we've discussed the prior art, and then register the South African patent based on what we've got there. So at least we're confident it should be valid if it did ever was ever needed. I think the examination process can be slightly different in Singapore from what I remember, unless that changed. There was like 3 different pathways to examination, but I think the overall requirements for patentability are very similar.
Thanks, Sarah. Edison's got a question that says, is it better to compile all technology into one IP application or split over several IP? Will this affect the costs incurred? Sarah, I think it's for you too.
Yeah, so there's different things to talk about here. So if you've got different inventions and they are classed as separate inventions, putting them all in one application, at some point you're going to have to divide them out into separate applications because you can only pursue one invention per application. So yeah, you could bung them all together in a priority application and then later on split them out. But if they are different inventions, and depending on what they are, you could use this as a way to kind of get longevity of protection. So you could file an application now, and then maybe in a year's time file another application to one of your other inventions, and then a year later file something else as you've developed it. Putting a lot of inventions in one application, it was going to be a big application. It's going to cost quite a bit to do that. The actual filing costs will be reduced because you're only filing one application, but ultimately later on you are going to split them out. So I don't think it tends to be a good idea to put everything into one, and keeping them separate also makes it a bit more flexible for if you if you're wanting to license them out. So if you've got one invention in the first application, second invention in the second application, and you want to license them to 2 different companies, that's easier than, you know, if they're all in one application. It just makes it more straightforward.
Okay, thanks, Sarah. That's usually what I would recommend too. I think, you know, putting everything into one big application tends to complicate, and unless you're very clear as to root of title, right? You know, in this day and age, because of the way companies collaborate, you need to be sure whether you actually have root of title. You could have co-owned IP with a collaborator or a consultant or someone, and you know, you don't really want to contaminate. So it may be better to keep things you know, separate. Again, that's part of your strategy, right? So one of the things that I realized when I worked with startups is cost should not be your only driver. Cost is a driver, but you know, we tend to make if we make decisions only on cost, and then you end up giving up a lot of flexibilities, or get yourself into a bit of a hole later, because if your patent as a whole gets you know, challenged, then everything falls. Whereas if you split it up, you know, you maybe live to fight another day, right? So again, this is part of the strategy that you need to sit with a good attorney will advise you on some of these things, right? So costs, I think, are important points for a lot of startups is an important aspect, but my own sense is it should never be the only driver, right? Let's see what else do we have now. Okay, Brandon asked, you mentioned several times the importance of the quality of a patent attorney. As a PI from university, how do you control the quality of the attorney? Good question. Maybe I'll take that, because you leave it to really it's your TTO, your IEO, right? And you have to trust that they have the experience to pick the right attorneys. We do that. Like Ken, we work with a suite of attorneys, and we work with attorneys that who's given us good service. We actually rank our attorneys and do some sort of analytics on how well they perform for us. And you look at special expertise. So we usually look for the individual, not so much the firm, because we in the market, we know who's good in a particular area. And sometimes it's not just the firm, but the specific attorney that we have to look to. So not a easy thing for the PI to do. Brandon, I think you need to trust your TTO that they have the wherewithals, right? Jin Siu had a question on: is it difficult to patent a medical device that is made on semiconductor processes? Sara, again, over to you.
You can get patents to medical devices. I don't particularly know a great deal about semiconductors myself, and if there's any strange patentability requirements around there, but yes, you can get patents to medical devices. In Europe and the US, in Europe you can't get patents to methods of medical treatment, and there's a way around that for therapeutics, but you can get patents for medical devices. You wouldn't be able to get a method of treating somebody with a medical device.
Thanks, Sara.
I just wanted to mention one point regarding the previous question. I think that was a good question for the academic people. And I think it goes back to another question also. The person asked that, or if a good patent kind of guarantees any success. I think for the first question, I believe there's no, and I can just simply say there are a lot of evidence. Example, our Singaporean universities have pile of so good patents, but as long as they don't go prove their value, they don't build any team around it, any commercial value, any business model, any customer for it, the value of the patent is very little. And that means whatever it is the best technology or worse, we don't know. So patents normally should be challenged in the commercial platforms and setups, then they have value. And we all know over that course, there are failures and successes. So there's no intrinsic value of technology when you just file it and feel like that is some common mistake. Many PIs may feel like, oh, our technology is the best and it will just, somebody will come and offer so much money. That never exists because it never been in the commercial setup. And that's a wrong idea. I think university should educate the academic people about it. Another thing is, just now was the question about, I think I should, I think it slipped from my mind. It was about, it was about attorney. It happened to us. I know that universities and institutions do their best to choose a good attorney and basically get a good counsel, but it may not be enough because they are filing so many applications. So one good way is, as I said, spin-off companies that if some right founders and entrepreneurs want to take over, they can just take over in the time of professional to PCT, and then they will work with the good attorneys if they really see the value, which we did. We changed the attorney. They did a good, decent job, but we changed and we improved a lot with a new attorney. So in the PCT filing, we had a kind of more complete and something that we like to have. So again, it's not under the control of academic people as the results, but I think if there's a clear plan of commercializing something, there's good ways of controlling it after the provisional, which normally universities do.
I think just something to add, I know you said earlier about cost should not be the main driver. I think for a lot of universities, cost is quite a strong driver so in my experience, universities tender out for attorney firms to work with. And I think quite a lot of consideration is given to the lowest price, which doesn't necessarily equate to the best application. So although perhaps like you had a poor experience with the university attorney, that might be because they work into quite a strict budget. And once you're away from that in like kind of real life and you're in charge, then, you know, they would perhaps work more like they would like to work, I think.
Thanks, Sara. Akbar. I mean, one of the things that, you know, in A-Star we've been looking at is actually quality. So we tend to file, in the old days, we used to file a lot of patents, and, you know, over time, we've been more circumspect about the patents we file, and we're going more for quality, just for numbers. So I think it's a fair point. You know, I mean, the budget's always a crunch, right, for public sector. I think when you, or even for publicly funded universities. So I think that's a point to take care. And Akbar's advice is a really good one. I mean, take it out early, and then you chart your destiny, right? Look, we've hit 5, and I don't see any other questions on the board. So, you know, it leads me to thank my panelists for you know, very interesting and very thought-provoking discussions. Very good points. I think I hope you know, the audience took away you know, good advice and good some pointers. And this conversation keeps going on, right? So I think it's a good start in many cases. And one of the good things about, you know, these sort of communities of practice is you learn from practitioners and you learn from each other. And I always advise my guys, right? I mean, good to have conversations with people in the industry to learn good points, best practices, learn from your mistakes. Even better, learn from other people's mistakes. It's a lot cheaper, you know. So I think, you know, having a community of practice in these sort of forums that what SGInnovate is doing is excellent. Applaud them for doing this. I think it really helps to build a startup culture in Singapore, and the knowledge base. I think, you know, coming from, you know, from the attorneys, for the practitioners as well as the investors, makes our life, you know, a lot easier if the knowledge base grows across the board, right? So with that, I'd like to thank all of you for your time and attention. Thank my panelists for their hard work. Brian, I'll hand it back to you.
Okay, thank you so much, Suresh. On behalf of SGInnovate, I would like to thank all our speakers, Sara, Ken, Akbar, and Suresh for sharing their valuable insight and knowledge today. I also like to give a special shout out to Costas and SINERGY for their help with bringing everybody together and organizing this event. So for audience today, thank you for sending in your questions and engaging with our speakers. Do also take note that we'll be sending out a post-event email with important information, including a recording for this webinar. So do keep an eye out for that. And with that, we've come to the end of our webinar today. Thank you all for spending your Thursday afternoon with us. And on behalf of SGInnovate, I would like to wish you all a great week ahead, and we look forward to seeing you again at a future event. Bye.
Thank you. Thanks, everyone.
Thank you, everyone.